The notion that one should fear retribution for offering assistance has no place in a modern Malaysia. My name is Paroshna and I will be presenting on the practicability of implementing Good Samaritan laws in Malaysia, akin to that of the Social Action Responsibility and Heroism Act 2015 or SARHA in the UK. How the implementation of such legislation will reduce the chilling effect of altruistic inertia or bystander apathy in Malaysia, and further, whether the implementation of such laws and the availability of such legal protection to Good Samaritans will encourage more people to step forward and aid those in need when required. Firstly, I would like to begin with a brief background of my research. Altruistic inertia or bystander apathy is the unwillingness to aid or help someone or act in a manner which is advantageous to another because it may result in a disadvantage to oneself. This is not a new occurrence. From an alarming universal perspective, it has enabled some of the darkest chapters in history, such as the Holocaust and the Rwandan genocide. In April 2015, SARHA was passed by the UK Parliament to protect those who, for example, would shatter the windscreen of a hot car to save a child. Essentially, Good Samaritan laws offer protection from being prosecuted to those who attempt to help those who are in danger or injured. In Malaysia, however, no such protection is accorded to Good Samaritans. Malaysia is well known for situations where Good Samaritans are sued by the people they help, thus resulting in a phenomenon where bystanders outright refuse to help those in immediate peril. To examine the feasibility of implementing Good Samaritan laws in Malaysia, I have studied the influence its absence has on altruistic inertia and its impact on the legal system in the UK. This was done to suggest possible modifications if such legislation were to be implemented in Malaysia. For the literature, I have reviewed altruistic inertia among medical practitioners in Malaysia in isolation, as it posits a distinct form of social responsibility that can be reintegrated into the general phenomenon of bystander behavior. It has been argued that a duty to act should be imposed on doctors in Malaysia, as medical neglect contravenes the Islamic principle of helping the needy and the inherent values of morally upright individuals. It can therefore be hypothesized that the dereliction of medical practitioners can be reduced because they would be legally predisposed to some form of retribution via the enactment of Good Samaritan laws. In considering the impact of SARHA on the legal position in the UK, there are three factors that are now judicially considered when assessing negligence. Firstly, whether the individual is acting for a societal benefit, whether they have demonstrated predominant responsibility and an act of heroism. However, a practical issue that requires deliberation is, for example, the phrase predominantly responsible under the Act, which appears to be ambiguous, and this may lead to variable judicial interpretations and legal uncertainty, as there is no objective standard as to what predominant responsibility may encompass. Although this research has achieved its purpose, there were some inevitable limitations, such as the sample in Malaysia being confined to medical practitioners. Therefore, it was difficult to generalize the behavior of bystanders, albeit some significant similarities. Additionally, the qualitative research method that was used undermines the validity of the analysis, as it was solely based on subjective opinions of authors. Based on the outcome of this research, a wholesome societal benefit is desired when it comes to situations which necessitate the assistance of potential bystanders. In addition to creating awareness among policymakers in Malaysia regarding the lacuna that exists in our legal system when it comes to protecting Good Samaritans. On top of that, it is hoped to encourage helping behavior among Malaysians when they are not faced with the threat of a potential legal suit. Although the sentiment of Sarha is greatly appreciated, the adoption of a similar law in Malaysia should be subject to modifications. Firstly, Sarha does not impose a legal duty on passers-by to intervene in emergency situations. Therefore, in Malaysia, the Act should be extended beyond protecting the intervening party by making it a legal requirement to offer assistance. To take it a step further, refusing to help should be punishable by law, although this may be subject to restrictions such as a situation of immediate peril. Furthermore, there should be further guidelines as to how the judiciary in Malaysia would resolve probable conflicts between the existing principles of negligence and the Good Samaritan Law, as it is unlikely that the court would favour a defendant who breaches his duty of care just because he was acting predominantly responsible or heroically. In conclusion, the absence of Good Samaritan laws in Malaysia appear to have an unresolved effect on altruistic inertia. Therefore, this research hopes to facilitate the implementation of such laws in Malaysia with the suggested modifications as a probable solution to protect and encourage Good Samaritans, especially in a developing nation like ours.